wait, I'm owed money, and now a company is in bankruptcy, and now I'm the one being subpoenaed? What is a subpoena even? What do I do about it? And why did I get it? So, welcome back again to Bankruptcy with Ben. As you can see, we're doing a little bit of traveling, but I didn't forget about you all. And I wanted to drop this video because it's an issue that's been coming up quite a bit lately, and I want to demystify the process. So, what is a subpoena? That's the first question, and I get it all the time. So, I think to answer that question, let's take a look and see what it is exactly. So, here we have right here. This is a subpoena. Okay. United States Bankruptcy Court. This is the official form. This is what it looks like. Subpoena for Rule 2004 examination. And you are commanded to appear at a date, time, and place set forth below to testify at an examination, and then a whole bunch of legal jargon. So this is what it looks like. Now, this is the basic form. You're going to see often attached to this form, there's going to be several pages of document requests, document demands, things that are being requested. So think of it like this. It sounds scary if you're not used to it, but in a more, in a sense, all it really is think of it as somebody knocking on your door saying, hey, can we chat, grab a cup of coffee, talk about what's going on? Obviously, it's more formal than that, but that is the basic idea. They just want information. Now, that's all. Now that we know what a subpoena is, it's a method used to get information from third parties. That's all it is. That's it. Now, why did I get one? All right, well, let's give an example. Tom Brady files for bankruptcy. I wish he had done that 15 years ago when the Dolphins were actually a somewhat competitive team and maybe could have had a chance if Tom Brady were not in their division. But what can you do? So let's say Tom Brady, again, he's now in bankruptcy. And let's say Tom Brady owed Dan Marino 1,000 footballs, right? Now, let's just say again, in this hypothetical, that Tom Brady set up a company. He called it Tom Brady One LLC. It's a company. And instead of paying Dan Marino back from himself, he paid Dan Marino back from Tom Brady One LLC, right? Now, Tom Brady owed money to a whole bunch of other people. And Tom Brady One LLC owed money to a bunch of people. Tom Brady has other creditors. They're all competing for the same Super Bowl, right? Tom Brady hogged all the Super Bowls, and it's not fair that all other teams, including the Dolphins, couldn't even get one. So Tom Brady has 7 of them, and Dan Marino has 0. That's not fair, right? So a whole bunch of other creditors are now coming in and saying, this is not fair. So now you get somebody who's called a trustee. The trustee is a neutral third party. Think of it almost like a referee, except we know the referees were never neutral with the Patriots. Tom Brady got every call that he ever wanted and then some. But in theory, this trustee is a neutral third party. Their job is to investigate Tom Brady's finances, right? So they could send out a subpoena to Dan Marino and say, hey, Danny, the money you were paid by Tom Brady One LLC, well, Tom Brady One LLC never had an obligation to pay you, right? It was Tom Brady personally that had the obligation to pay you, not Tom Brady One LLC. So, hey, Danny, open up your books and records and let's see what really happened here. Let's see what was really going on with that transaction. Were you maybe getting money that should have gone to, I don't know, Bill Belichick, or any other one of Tom Brady's creditors? Again, everyone's fighting for the same pot of money. So a trustee wants to look at it and say, was everyone that was repaid, were they repaid fairly and squarely, or was there some kind of dealings where they got money ahead of another party that should have gotten the money? So even if you did nothing wrong, per se, that's the job of the trustee to investigate and see, okay, was everyone treated on a kind of even footing? Now, take a step back. Okay, I know what it is. I know why I got it. It's not fair. It sucks. I did nothing wrong. What do I do about it? The answer is you have to respond. You have to cooperate. Now, one thing to be aware of, you should definitely hire an attorney. And I'm not saying that just because I'm an attorney. I'm saying that because it's necessary to protect you. A, you want to make sure you're in full compliance with what's being requested. But B, equally as important, if there's information that's contained that you should not have to share, you do not need to volunteer information that's not requested of you, right? So if, for example, this trustee goes and says to Dan Marino, I want all of your WhatsApp communications that you ever had with Tom Brady from January 1st, 2000 to January or December 31st, 2010, then you, Dan Marino, you don't need to suddenly also provide emails, right? You only ask for WhatsApp communications. So if all you ask for is WhatsApp, you just give the WhatsApp. You do not need to give emails. You're not asked for those emails. But at the same time, if you're asked for, let's say, all communications, well, you want to make sure that you're actually giving the WhatsApps, the emails, the text messages, and so on and so forth. So you want to make sure two things. A, you're properly responding and covering the information that has been requested. And B, you want to make sure you're not disclosing information that you are not otherwise required to disclose. And that is why you need an attorney to sift through all that process, see what is responsive, what's not responsive. And then in a very, very small percentage of cases, and I think this should actually apply to Tom Brady, not to Dan Marino, is if the information would implicate you criminally. If, let's just say, there was a text message from Tom Brady where he says, yeah, I deflated all the footballs, and Dan Marino says, yeah, I know, Tom, you deflated the footballs. I am paying you an extra $10 million to deflate the footballs, and we're going to purposely throw all the games against you and let you win and let you have your Super Bowls because everyone feels bad for you, Tom, and we just want you to have the glory because we love you so much. So that would be pretty damning if Dan Marino sent those messages. So in that case, if a lawyer is reading through these messages and sees Dan Marino admitting that he threw a game, right, that might be a situation where you want to plead the fifth. So you do not ignore the subpoena, but you are not obligated under the Fifth Amendment to produce information that would implicate you criminally. So in that case, and again, you should consult with a criminal attorney before this, but you would respond in such a hypothetical that you are invoking your right under the Fifth Amendment, protect you against self-incrimination. That's the only time that you would simply not respond. You could also claim certain privileges, attorney-client privilege, so on and so forth. Again, that's why you want somebody to sort through all that information. That demystifies the process a little bit, I hope. Hope everyone got value out of it. If you see a subpoena, it's not so scary. Contact myself, attorney. Make sure you're handling it properly. We do this thing all the time. We're very good at it. Don't get scared. Just take a deep breath and you'll get through it. That's all for today. Hope everyone got some value out of it. Don't forget to like, comment, and subscribe, and we'll see everybody on our next one.